The theme of this whole conference is privacy and innovation. And I don't think there's anything more innovative about the internet in many ways than user-generated content. What is more revolutionary than the fact that everyone, in a way, has become a publisher? As Daniel Solov says, today we are the media. Hundreds of millions of people publishing personal information, including about others. Now, that raises some issues about their own individual obligations, potentially under data protection law. I'm actually going to rather park that, because it's not the prime focus. It's a very controversial area in itself. But most of these individuals use platforms or services to communicate. It's not that they're directly communicating on the internet. They interact in complex ways with the platform, with the world at large. And it's their liability, their responsibility under data protection law, particularly for third-party personal information. So not the personal information that users themselves are disclosing. There may be issues around informed consent there, but it's a relatively simple area. But what about all the third-party photos, images, audiovisual, simple plain text that is being distributed? And yes, this is coming out of about 2 terms of academic work. There is a full paper up on the Social Science Research Network if you have some light bedtime reading you would like to carry out. But I know that, in this conference it's very much about, different areas, academics, policymakers, data protection authorities, business. And I want to make this practical as well. I'm sure many of you actually in many ways have users who contribute content to your services. I'm very much an academic. I'm going to start with some rather boring definitions, I'm afraid. So user publishers, user-generated content, natural persons who are acting non-professionally, but part of a wider group of what I'm calling original publishers, those who are directly and initially responsible for the immediate publication of personal data. Of course, they can be large corporate entities. The BBC website in this country may be the clearest example, but as a phenomenon now, they are overwhelmingly very small users. Maybe simply it's a hobby, it's a pastime, or even they don't even see it as a pastime. It's just a natural extension of their life. The intermediaries, a very broad group. Anyone who carries out directly, and that means usually in an automated fashion, publication-related processing linked to that original, often user publication. But that might be anything as simple as simply hosting the content, but it might be about arranging, organizing, pushing, pulling the content in all sorts of myriad ways, which may not have even been in the mind of the original publisher, the user generated, the content person. So I'm going to look first at where the law was when we codified those frameworks around the turn of the millennium. And then I'm going to look at where we seem to be now in the case law. And then I'm finally going to turn to see where we're going with the General Data Protection Regulation. And I suppose, if I'm in all honesty, where in a way I think we should go to make sense of this really messy area of law. Okay, so round about the year 2000, I think there were 3 laws in play, but they were 3 laws in play which were operating in separate spheres. So we had the Data Protection Directive, which had come into force in the late 90s, dealing with those who actively managed personal information, who, whether jointly or alone or jointly with others, determine the purposes and means of processing. You all know this. We also had another codified framework, the e-commerce framework, the intermediary shields in the e-commerce framework, which Stuart tells me has never been explicitly discussed at this conference in 30 years, I suppose. Who here actually has heard of the e-commerce? Oh, well, almost all of you. So the e-commerce framework, originally in a very different socio-technological environment, was about those who are passively either just simply a conduit of information on the internet from point A to point B, or in order to make that efficient, they're temporarily storing. None of this is truly publication. This is sort of disclosure to one or more persons. But the final one is, it's about passively hosting the content on behalf of others. And you can begin to see why. Oh, and by the way, obviously human rights influenced all of this, so there was general human rights law. Privacy, rarely data protection in and of itself mentioned, but privacy influencing very much data protection, freedom of expression influencing the intermediary shields, but I don't think it was seen as necessary to constantly and always be discussing, well, is there a need for proportionality or human rights? I think it was hoped that the codified framework would provide the answers. And that the split between these two codified frameworks, Article 15B of the e-commerce directive, saying quite explicitly, questions related to information society services covered by the Data Protection Directive are outside the scope of this law. So those who are actively controlling look to the data protection framework.